Hello. In this short lecture I'm going to talk you through how to answer a problem question about copyright. It's a question that appeared in the University of London's International Programme LLB paper for 27. It's the resit paper, and it's question 2. The star of the story is Professor Seathwaite. If you're on the University of London International Programme, it would probably be a good idea to have a copy of the question in front of you. I'm not going to reproduce it here because when I'm talking about copyright that really couldn't be more inappropriate. But I will give a brief summary of the facts so that if you don't have access to the original you can still follow what I'm talking about. So what does the question give you? First of all, the facts. Professor Seathwaite gives a lecture on contemporary music, and in the course of doing so he sings his own composition, and he also includes in his slideshow some photographs which he's downloaded from publicly available parts of the World Wide Web. Unknown to him, one of his students records the lecture and posts it to social media, and the question tells us that the whole class has access to it. It doesn't tell us how many people are in the class, nor does it tell us whether everybody else in the world has access to it as well. The next thing that happens is that a student choir sings the professor's piece of music in public. Then Dr. Uber writes an article based on the ideas which he heard expressed in the lecture which he attended. Although those are matters that Professor Seathwaite doesn't like, then the examiner requires you to turn completely around and consider something that Professor Seathwaite has done which the photographer doesn't like, because a photographer appears, or rather a body that represents a photographer, and some of the photographs which were used in Professor Seathwaite's slideshow were created by the photographer. That's about as much as the question tells you. It leaves a lot to the imagination. So if you've found this question in an exam, you've glanced through it quickly to try and get an idea about what it's about. You'll have seen that it's about copyright. You'll have got to the end of it, and you'll see that the examiner has asked you to discuss certain issues. It's more usual to find that the examiner is asking you to advise, but here you're asked to discuss causes of action. In other words, your answer is all going to be about who can sue whom. It's a question about copyright infringement, but inevitably questions about copyright infringement bring with them issues about the subsistence of copyright and about possible defences. So your starting point for answering the question should be to identify the copyright works that are involved here. You were asked to discuss causes of action under the Copyright Designs and Patents Act 1988, but I hope you've identified fairly quickly that the only causes of action within your syllabus are going to be to do with copyright. Well, that's certainly true of the University of London syllabus. Some other institutions might cover rights in performances. Copyright is part 1 of the 1988 Act, rights in performances are part 2. But let's leave that to one side because I'm convinced that the examiner didn't have that in mind. There are 3 copyright works here, 2 of them apparently created by Professor Seathwaite, the other one the photograph or photographs created by the photographer. The professor's lecture is a literary work, anything which is written, spoken or sung other than a musical or dramatic work, but he's also, as it were, embedded a musical work into it. As far as copyright law is concerned, the 2 retain their distinct identity. You can't merge them together. The lecture and the musical work have got to be treated as separate. And in each case, although the question is going to be the same each time, I think, or the answer is going to be the same, in each case we need to ask ourselves, first of all, are the requirements for qualification met? Whenever you write an answer to a problem question on copyright like this, you probably need to sneak this in somewhere. Don't spend a lot of time on it, but don't let the examiner think that you didn't realise it was an important point. If the requirements for qualification are not met, then there's no copyright, and therefore probably no question for the examiner to ask you about. So the requirements are going to be met in some way, almost always. And incidentally, that doesn't apply in the same way to questions about design right, which have got different qualification requirements. But in the copyright world, you'll ask and answer the question very easily. Section 154 of the Copyright Designs and Patents Act tells you that if the creator of the work was domiciled in the United Kingdom, then their work will be protected by UK copyright law. So we don't need to ask about Professor Seathwaite's nationality or anything like that. It's safe to assume from the facts of the case that he's going to be living in this country while he teaches at the university. I think it's probably a good idea to tell the examiner that you're making some assumptions there, but you don't really need to get into the substantive law. The answer is there pretty easily. Secondly, are the works, the literary work and the musical work, recorded in writing or otherwise? That's the requirement of section 3, subsection 2, illustrated by a number of cases that you're probably quite familiar with, including Walter against Lane. And the answer is yes. The lecture and the musical work have been recorded. We're not told whether the professor spoke from a complete script of his lecture, or whether he had notes, or whether he extemporized. If he had slides, then perhaps he was using the slides to remind him what to say. His musical work is probably more likely to have been committed to paper, simply because that's the way that composers tend to work. But in any case, the fact that Tammy's made the recording, even though she did it secretly, even though she didn't presumably get the professor's permission, I think if she'd got permission then it wouldn't be appropriate to say that she'd done the recording secretly. That doesn't make any difference. She doesn't need permission from the person giving the talk. In fact, she's created her own copyright work, a sound recording. She can't do very much with it because her rights in it are entirely dependent on the copyright in the literary work and the musical work which are recorded in it. But her activities have brought into existence a new copyright work, a sound recording, and also fixed copyright in the lecture if it hadn't been written down before, and indeed the musical work if it hadn't been previously written down as well. I haven't mentioned Tammy's sound recording again because there's no suggestion anywhere in the question that copyright in it has been infringed, therefore we don't have to think about causes of action that might relate to it. That's simply not part of the answer that the examiner is going to be looking for. So looking at the lecture and the musical work, the requirements for qualification appear to be met. They've been recorded in writing or otherwise. Copyright will protect them if they are the professor's own original work. There's nothing in the question that suggests that the originality of the work is in issue, so you don't really need to go into very much more detail to satisfy the examiner on that point, I don't think. It might be appropriate to tell the examiner that you recognise that UK copyright law is in a transition from the traditional approach, which amounted to little more than looking to see whether copying had taken place, and a much more rigorous approach under the ruling of the Court of Justice in the Infopack case, where we have to ask whether the copyright work is the author's own intellectual creation before it will be protected. So you've certainly got to mention the originality requirement, for the simple reason that copyright doesn't protect literary and musical works, it protects original literary and original musical works. So you need to make sure the examiner understands that you are aware of that, but the facts don't give us any reason to believe that the works aren't original, so we can move on. Move on to the next point, which I think is important to mention, although it doesn't actually go to the question of whether there are causes of action. It will go to the point of whose cause of action it would be. Normally the first owner of copyright in a work is its creator or author, but where the author is an employee and creates the work in the course of their employment, the rights will vest in the employer. And I think it's a fair bet that the professor is employed by the university, and I think it's well worth telling the examiner that you recognise that that rule might be applicable in this case. It's also possible, incidentally, that his contract of employment says that he can have the copyright back, so it would operate to transfer the copyright back to him. I think the important point to recognise here, though, is that there could be an issue about who owns the copyright and therefore who's entitled to take action. I think before you move on to consider the particular issues in this question, while you're talking about the subsistence of copyright, it's worth telling the examiner about copyright in the photographs. You could slice up your answer in a different way, talk about all the professor's issues first and then talk about the photographer's issues. I just think it's neater to deal with subsistence all at once. So again, with photographs, you're going to tell the examiner that you recognise photographs are a type of artistic work for copyright purposes. They're protected provided they're original, and the photographer has got to qualify for protection in the same way that the professor did. Otherwise there's going to be no copyright to argue about. As I said, the question is remarkably vague about what the photographer's up to here, but I think we can assume that through the representative body mentioned in the question, the photographer is trying to enforce copyright. So having established what copyright works there are, or may be, the next step is to define infringement. Tell the examiner that you know what constitutes an infringement of copyright. That requires you, first of all, to tell the examiner what exclusive rights copyright owners are given. You don't need to trot them all out, I don't think, in your exam. That would be too time consuming, and many of them are not relevant to this question. But you would talk about reproduction in any material form, distribution to the public, communication to the public, and performing in public. Those are the exclusive rights that copyright owners have which are engaged in this problem. Then tell the examiner that it's an infringement to do a restricted act without consent to the whole or a substantial part of the copyright work. The issue of substantiality is going to be important shortly, so we'll put it on the table now. Also tell the examiner that you're aware that defences are available in the form of permitted acts. And please, always in situations like this where the legislation uses a particular expression, use that expression yourself. The legislation doesn't talk about exceptions to copyright protection or anything like that. It talks about permitted acts, which are contrasted, obviously, with the restricted acts. So the next thing is to consider what each of the potential infringers has done. Tammy made a recording of the whole lecture and the whole musical work without consent, so no need to consider whether there's a substantial part involved. She just took the whole lot, which makes it easy. Making the recording is reproducing the work, and that's the first of the restricted acts. She's gone on to post her recording on social media, which looks very much as if it amounts to a communication to the public. Here the question is a bit vague. We don't know whether access is limited to other members of the class, or whether anybody else on the internet can get access to it. That's unlikely to make any difference to the question of whether she has communicated it to the public, because the public generally means more than just an immediate domestic circle. In other words, her classmates are probably going to be a big enough group to constitute a public for these purposes. So whenever you talk about an infringement, you should also talk about defences, but I think there's a risk here that you could talk about permitted acts at some length and have to conclude that none of them is going to help Tammy one little bit. not fair dealing for the purposes of non-commercial research and private study. It's certainly not private study because she's made it available to her classmates. It's certainly not research because researching something doesn't involve sharing it with all your classmates. There's no suggestion that she's done anything like criticism or review. She could possibly argue that she's reporting current events because the fact that he gave the lecture is a current event. But never lose sight of the fact that these important first group of permitted acts in the legislation are just specific cases of fair dealing. Over and above everything else, it's got to be fair dealing. And taking the whole of somebody's copyright work like that is highly unlikely ever to be considered fair. There are some permitted acts to do with education. Section 32 says fair dealing with a work for the sole purpose of illustration for instruction does not infringe copyright. It's got to be non-commercial, which appears to be the case here. It's got to be by a person giving or receiving instruction, and Tammy is receiving instruction. And it's got to be accompanied by a sufficient acknowledgement. As far as we know, she hasn't acknowledged the professor, but perhaps she has and we just haven't been told about it. Can it truly be said to be for the purpose of illustration? It doesn't look much like it. And finally, is it fair dealing? And I think she's going to face exactly the same problem under Section 32 as she would have done under Section 31. So as I said, don't spend too much time on the defences that she might have, because she hasn't got any really. Section 32 is going to be much more useful when we come to deal with the photographs. So moving on, what have the choir done? They've performed the whole musical work, and it seems to be that they did it in public. A performance has got to be in public if it's going to be an infringement, provided it met that requirement. And that doesn't mean to say it's got to be open to members of the public to come and buy tickets. It could be a performance before their classmates. It could be a performance before another group of students or within the university community. That can still count as public. And you should be aware of some cases that illustrate that point. Turner and Performing Rights Society tells us that having a radio playing in a factory, it amounts to playing the music in public. Again, I don't think the choir has got any excuses, no defences. The only thing I would say before moving on, and this is highly unlikely to feature in your answer I think, is that in reality what the choir is doing is probably going to be dealt with by them getting a licence from the Performing Rights Society, or PRS as it's now, I think is its official name, assuming that the professor is a member of PRS. And if he's a member, then the licence holder will make a return to PRS saying they've performed his piece of music, and he'll get some money for it. Usually it's the venue that will have paid for a licence, not actually going to be the responsibility of the choir. But if they've just gone and done a performance somewhere which wasn't licensed, then they could be in trouble. So you're asked to advise about causes of action. The choir, or the members of the choir, if the choir isn't an identifiable body in its own right, can be sued for infringement. But in the real world they're not going to be, because what's the measure of damages? It's going to be tiny. It certainly won't be worth the professor's while taking action to enforce that, unless there's some other factor at play, like the choir have spoiled the world premiere that was due to take place at the Royal Albert Hall and be broadcast on the BBC. That could bump up his damages a bit. Next we've got Dr. Uber and the journal for which he wrote, Musicologia. The examiner could have been a bit friendlier by telling you what Dr. Uber had done. He wrote an article based on what he'd heard at the lecture. Big deal, it doesn't even tell you whether he quoted anything that the professor had said in his lecture. If all he's done is taken the ideas that the professor expressed in the lecture and put them in his own words, There'll be no infringement of copyright because there's no copyright in ideas. And you might again mention the InfoPack case, which is authority for saying that if Dr. Uber is going to have infringed copyright at all, he's got to have taken some of the professor's own intellectual creation, and ideas are not one person's individual creation. Assuming that the examiner left this vague because they wanted you to write about all the possibilities, you could speculate about whether Dr. Uber has quoted from the speech and whether those quotations are substantial or not. He might have a defense of saying that he hasn't taken a substantial part. Then he runs into the problem under the University of London University Tutorial Press case that prima facie what is worth copying is worth protecting, so the mere fact that he saw fit to quote it means that it's a substantial part of the whole. He's going to do better to look at section 30 of the Act, which includes a permitted act that relates to quotations. That might help him. It's going to have to be fair dealing, but it doesn't sound to me as if he's taken too much, and he hasn't done anything which is going to interfere with the professor's normal enjoyment of his copyright in the work. And incidentally, I think we can assume that Dr. Uber, if he's done anything which might infringe copyright, is only going to be infringing copyright in the literary work, not in the musical work. He might also be in a position to say that what he's done is fair dealing for the purposes of criticism and review, and he might also be able to argue that it's for the purpose of reporting current events. I think you can deal with Dr. Uber and Musicologia together, because although they're doing different acts, the most important thing the examiner is going to be looking for here is their defences. So while Dr. Uber has reproduced, well, we don't know what he's reproduced, but for the sake of argument, say it's a substantial part of the copyright work. Whatever he's reproduced, Musicologia has published it. So publishing, making available to the public, is a different restricted act. So they're guilty of a different type of infringement, but the same defences are going to be available to them. In all questions like this, the examiner is interested in seeing what you know, and the question's designed to bring that out, not to give you an opportunity to act as judge and decide whether an infringement has taken place. That's not the purpose of the exercise at all. So that deals with the bulk of the question. The photographer looks very much like a sort of arbitrary add-on. Perhaps the examiner didn't think they'd asked you enough. So you've identified that an original photograph is a type of copyright work. Of course, we've got a new creator here. The photographer is making his or her first appearance in the question, so it's relevant to ask whether they qualify for copyright protection. In real life as well, you would also want to know something about the rights of the body that claims to represent the photographer. It suggests that the body, whatever it is, doesn't own the copyright, but it's acting as the photographer's agent in some way. The professor got the photograph off the internet, but that makes no difference to the question of whether he's infringed copyright in doing so. Just because it was on a website doesn't mean to say that the copyright owner is allowing all and sundry to use it in whatever way they like. And the professor has downloaded the photos. That means he's reproduced them, made copies without authorization. Could have been a completely different story if he'd used a link. But there aren't any other possible infringements. It's just the matter of making the copies. He hasn't issued copies to the public. He's merely displayed the photographs in his slideshow, and that isn't something that requires copyright consent in itself. Nobody else has done anything with the photographs. It would have been a much more interesting question if Tammy had done something that involved copying the photographs as well, but she didn't. So this problem with the photographs begins and ends with the professor. And actually this is a very common thing to encounter in real life. Rights in photographs very often belong to big agencies like Corbis and Getty, and they make a lot of their money by chasing people who reuse their photographs because they found them on the internet, thought they were free to use. They've made a copy, put it on their own website or done something else with it like that, and then they receive a bill for the normal license rate which the agency would charge. However, it wasn't my purpose to try and teach you about things like that. What this lecture was for was to tell you how to go about answering the question. I hope it's done that. If it has, give it a like, and then I'll know that it's worth doing more, and also subscribe to the channel so you find out when I do more. Thanks very much for listening. Bye.